Welcome to our session on design as intellectual property. Today, we'll explore India's Designs Act from 2000, what counts as a design, how you can register it, and some real-life examples. This is part 6 in our IP Essentials series, and it's designed for anyone curious about protecting creative work. Let's get started. Today, we're diving into design rights. Why protecting how your product looks is your right, whether it's a bottle, a piece of furniture, or a smartphone cover. We'll explore what design intellectual property really means, how it's different from other types of protection, and the basics of India's Designs Act from 2000. Then, we'll see which designs can be registered, walk through the registration process step by step, understand how long protection lasts, and look at real-world cases where design rights changed everything. Let's get started. When it comes to law, look really matters. It's not just inventions or brands that get protection. The way a product looks can be protected too. That's what design intellectual property is all about. Think of the Parle-G biscuit wrapper, or the Bajaj Chedak's body shape, or even Apple's iPhone grid layout. These are all registered designs. Take the Coca-Cola bottle's iconic curved shape. One design can make a huge difference. When we talk about design in the context of intellectual property, there are a few key things to keep in mind. First, the design has to be industrially reproducible, meaning it can be made more than once, not just a one-off. It also needs to be new, something that hasn't been published or used before, anywhere in the world. The design must apply to a tangible product, not just an idea or concept. And importantly, design protects only what the eye can see, the shape, lines, colors, texture, or pattern, not the function. This is the essence of design under the Designs Act of 2000 in India. Let's take a look at India's Designs Act of 2000, the key law that protects industrial designs here. It's different from copyright or patents because it focuses solely on the visual appearance of a product. The Act replaced the older Patents Act of 1970 when it came into effect, alongside the Designs Rules of 2001. Recently, there have been updates to online filing and fees, making the process smoother. India is also part of the International Paris Convention and the Hague System, which means international design applications are now possible. When it comes to registering design layouts, not everything qualifies. For example, trademarks, brand logos, or purely mechanical inventions can't be registered here. Neither can designs that are already published, national emblems, or anything scandalous or obscene. On the other hand, the visual look of automotive parts, footwear, packaging, or even furniture can be registered. So can the ornamental design of jewelry, textile patterns, and container shapes. This slide helps us see clearly what's eligible and what's not. Registering a design in India takes about 3 to 12 months. We start by searching to make sure no similar design is already registered. Then, we prepare the application, filling out the form and attaching clear views of the design. Next, we identify the right class for the design from the 32 Locarno categories. After filing the application and paying the fees, the controller examines it. If there are objections, we get time to respond. Once resolved, the design registers and protection begins immediately. Let's talk about how design registration works in India and how it's different from copyright and trademarks. Design registration lasts for 10 years initially, starting from the filing date. You can renew it once for an additional 5 years, making a total of 15 years of protection. But renewal is crucial. If you miss that window between year 10 and 15, your protection ends. Unlike trademarks, this isn't forever renewable. After 15 years, the design enters the public domain. So, keep track of those dates. When it comes to protecting a product, multiple types of intellectual property can come into play: design registration, trademark, patent, and copyright. Each covers something different. Trademarks protect your brand name and logo. Patents cover new inventions. Copyright applies to creative works like art, writing, or code. Design registration safeguards the product's appearance. Costs and durations vary, but combining these protections gives you the strongest defense. Knowing when and how to use each one is key to securing your innovation and brand for the long haul. Design can be powerful. Take Christian Louboutin's Red Soul. It's more than just a color. Courts recognize that, in certain contexts, color itself can be a protectable design element. Then there's Bajaj, who took TVS to court over design features of their motorcycles, a landmark case in India. Coca-Cola's iconic curved bottle dates back to 1915, protected as both a design and a trademark. And Apple enforced design rights on the iPhone's shape and icon layout, winning over $1 billion lawsuit against Samsung. These real cases show how design rights have truly changed the game. Let's talk about common mistakes to avoid when protecting your design. First, remember, if a feature works, it's not a design, it's a patent matter. Design protection covers only the visual or aesthetic parts. Filing in the wrong Locarno class is the biggest cause of rejection, so choose carefully or get expert help. Also, design registration lasts 10 years with an optional 5-year renewal. Miss that, and competitors can copy freely. Don't rely only on copyright. Design registration offers stronger protection for industrial products. And never disclose your design publicly before applying. That kills novelty. Apply first, then show. Let's sum up the key takeaways about design protection. Design IP safeguards the visual appearance of a product, not how it works, just how it looks. In India, designs are registered under the Designs Act 2000, covering 32 Locarno classes. Protection lasts for 10 years with a possible 5-year renewal, totaling 15 years. Remember, register your design before you launch. Once it's public, you can't apply. Also, design registration is different but complementary to copyright, patents, and trademarks. And finally, common products like bottles, furniture, fabric, and gadgets can all be registered. That wraps up this episode on copyright, duration, and the public domain. Next time, we'll explore how long protection lasts, whether you can use works for free, and what public domain really means. Don't forget to like, subscribe, and share your thoughts. See you in episode 7.